All right, I have 12:55. Thank you so much, everyone who was able to join us early. We really appreciate your help in that. My name is Mary Tiernan. I'm the Outreach and Education Coordinator for the EEOC's Philadelphia District Office. My colleague Marcel Baldwin and I helped organize this, and we're thrilled that you can join us today. This is a Zoom webinar, so it's a little bit different maybe from Zoom meetings or team meetings that you've experienced over the last year. For a Zoom webinar, you've been muted when you came in. There's no opportunity for you to go on camera. It's just the nature of the webinar. We appreciate your understanding on that. We have a chat running. You might want to say where you're joining us from. So far, we've seen people from across the country, and that's really exciting. So if you want to give a little introduction in the chat, we appreciate that. Our colleagues, Terry Peter, will be monitoring the chat. If you have questions about logistical matters, you can ask Terry about that in the chat. Our presenter, Kat Ryder, will be taking questions at the end of the presentation. If you look down on your screen, if you kind of scroll down to the bottom of the black screen there, you should see a Q&A box. That is for questions and answers. So if you put a question, if you have a substantive question, please put that in the Q&A box. Our colleague Elaine MacArthur from our Tampa office, the Miami district, she'll be helping us monitor the Q&A with Marcel and me. So any substantive questions, please put in the Q&A box because the chat can go very fast and Terry cannot copy things from the chat and put it into the Q&A box. We've had questions of when will the materials be provided, and they'll be provided after the program. So thank you for your understanding on that. We've had some questions about CLE credits. We did not apply for credits from Pennsylvania. Right now, we do not meet the requirements for virtual providers under the PA requirements. The Ohio, West Virginia, and Delaware applications are pending. This program has been approved for HR, CI, and SHRM credits. And one last thing, you may see at the bottom, I've told you if you have questions to please go down to the Q&A. There's also the chat, so you'll see the little icon for Q&A, the little icon for chat. You may see an icon for a raised hand, but we can't really monitor that very well with so many people in the room. So again, if you have any questions, logistical, put it into the chat box. Our colleague Terry will be helping Marcel monitor that. If you have a substantive question for Katrina Greider, please put it in the Q&A box, and Elaine MacArthur and I will pose those questions to Kat at the end of the program. I have two quick polls before I'm going to turn this over to our director, Jamie Williamson. One of the things that we're very excited with this technology is the opportunity to do a quick poll, and these are anonymous. But we'd like to just get a little bit of your input on this because with the technology, it's been very exciting and we want to see how you feel about this going forward. So when you return to the workplace, would you prefer in-person training, virtual training, or maybe a combination? Ooh, we're getting some nice votes here. This is interesting. Wow. Okay, I thought I'd see a little bit more for in-person training, but there is something really nice about having the virtual training as we're going to see in just a minute or two when Kat officially gets started. I'm going to give this one, maybe 2 more seconds here. So 30, okay, let me end the polling here. Thank you for doing this. 31% said virtual training, 64% said a combo, 5% in person. Thank you on that one. Okay, now we are going to do our second poll, if you don't mind. And for this one, what's your preference for the length of a workshop? We have different virtual programs right now this year, 1 hour, 2 hour, 3 hours, 5 hours. If you wouldn't mind, what's your preference, please? So what's your preference for the length of a workshop? 1 hour, 2 hours, 3 hours, 5 hours? I'm just going to give this maybe another 2 or 3 seconds here because I'm really eager to turn this over to Jamie and to hear from Kat. This is going to be a wonderful presentation. All right, let's end the polling on this one. Okay, preference 2 hours seems to be the winner. So good to know on that one since this is a 2 hour. And then 1 hour. 1 hour, we have that one. And then 3 hours. Thank you so much for helping us with that. And now, Jamie, I see Kat here, eager and raring to go. But can I share Jamie for a minute, Kat? Do you mind? Jamie, would you mind introducing Kat for us? Thank you, Jamie. Thank you, Kat.
Thank you so much, Mary. And thank you all who are attending this wonderful event today. I've had the pleasure of actually hearing Kat do this training quite a few years ago, and which is when I fell in love with her ability to do training. She's an exceptional trainer, so I know you're all going to enjoy what she's bringing you here today. What is nice about what we're doing here is giving you this information, and I'm glad to see that many of you do want to do it virtually. So thank you for that. That has been one of the questions that I wanted to know. But we have the ability to bring Kat here because it is virtual. So thank you all very much for spending your time with us today. I am sure that you will get out of this training as much as I did when I took it many years ago. I'm going to turn it over to Kat Greider. She is our Associate Director of Curriculum, Education, and Training out of our headquarters in Washington, D.C. Kat, thank you so much for being here and your presentation today. We're all excited, so with no further ado, I'm going to get you started. Thanks, Kat.
Appreciate it, everyone. I am so excited to talk about this topic today. It's actually one of my favorite topics, the leave maze, managing and working through and processing the FMLA, the Family and Medical Leave Act, the ADA, the Americans with Disabilities Act, the PDA, the Pregnancy Discrimination Act, and workers' compensation. This is an issue that is a top issue for many employers. It's been an issue that's also been prevalent in the COVID pandemic time as well. What I'd like to do today, though, is to talk about some very practical stuff. So we'll get into the weeds just a little bit. But before I get started, the one thing I do want to tell you is this. When we talk about the Family and Medical Leave Act, the FMLA, just know that that law is enforced by the Department of Labor. The EEOC enforces the other laws that we're going to be talking about today, the ADA, the PDA, and Title VII. But that doesn't mean that we can't talk about how all of these things come together. So it's a manic Monday. I thought we'd get started. Hang on one second. Whoop. Let's start with this. You can't make this stuff up. I want to share a couple of stories with you. Let's now talk about Facebook Frank. And what we're going to discover, and as we go through this presentation, are boundaries that managers need to have when they're discussing these kinds of things. So here's the story. Frank is friends on Facebook with someone that he works with in his office. He is the supervisor, and he supervises this female employee. And one morning she posts on Facebook, "Oh my gosh, I just found out that my sister has breast cancer, and I'm just very upset about that." Well, there's a whole bunch of discussion, as you can well imagine, on that Facebook posting. So they're at work. What does Frank do? Frank walks into her office and he says this, "I saw that posting that you put up there about your sister, and I'm very sorry to hear about that. Are you going to get it? Because you know they have those tests. You should go get tested for that. And when you do, let me know." Yes, he said that. Why he said that, we'll never know. But that was a very inappropriate question and inappropriate discussion for him to have with her. But then it gets worse. He leaves her office, then he goes to HR, and here's what he said to HR. "You need to start monitoring her if she's going to take that FMLA leave, because I can't afford to have a whole bunch of people out in my department, and I want you to track her attendance." So what do we have? Well, we've probably got a FMLA interference brewing there. We might have something brewing there with the ADA to the extent that he is perceiving her or even regarding her as having a disability for a condition that he doesn't even know that she has. But it's those kinds of things that get managers in trouble. Let's talk about that for just a second when we talk about social media today and Facebook. You know, should we really be friends on Facebook as supervisors with people that we directly or indirectly supervise? Is that really a good idea? think about all of the things that you can find out about your employees on Facebook. And I ask employers to think about this, particularly managers and supervisors. Do you really need to know that information? Sometimes you don't want to know. And I think maybe at the end of the day, might it not be a better position to say, I didn't know about that. I didn't know someone had that condition. I didn't know that someone had a disability or any of those other kinds of things. So those are the things that I'm talking about when I mention having professional boundaries at work, particularly when it comes to these issues. But then I have another friend. I'm going to call him WebMD Wayne. Let me tell you about what Wayne did one afternoon. Wayne is also a supervisor, and he's sitting in his office across from the break room area. There are two of his employees in the room, in the break room area, getting some coffee and just having a discussion. And one of her says to her coworker, she said, "You know what? I'm just having a very difficult time remembering things anymore. My brain just doesn't have wrinkles anymore. It's just very smooth." And the two of them kind of chuckle about that and laughed, and then they went back to their workplace. What did Wayne do? Well, Wayne decided to go on WebMD, and he decided to do some research about the early symptoms of Alzheimer's and dementia. Then he downloaded that material, he sent it to the entire team, and he said, "We all need to support Janet because she's having mental problems and she's exhibiting the early symptoms of Alzheimer's." So of course, her team members go into her office and they were like, "Janet, I'm so sorry to hear about this. You didn't tell us about this." And she said, "What are you talking about?" "Well, I know you have dementia and early Alzheimer's. That's what Wayne said." She's like, "What email? What did Wayne say?" Now, some of those things on the surface seem like they're kind of funny and amusing, but think about how many times those conversations go on in the workplace that are not appropriate and that would be violations of the Family Medical Leave Act or the Americans with Disabilities Act or the Pregnancy Discrimination Act, or, as we'll talk about a little bit later, maybe even workers' comp retaliation. So that brings up the next thing, talking about maintaining professional boundaries. I have to be very candid, ladies and gentlemen. We've just got to tell folks in the workplace, don't be a motor mouth about confidential medical information of others. What does that mean? Well, it means not posting that kind of stuff on social media. It means not posting someone's request for reasonable accommodation on social media, or even sending emails or text messages across the office about someone's condition. Sometimes I have to remind employers that you can't even do it if you're friends, particularly if you are in a position as a supervisor. You can't do it even if you're related either. Sometimes you have this issue that comes up in the healthcare industry, and it's pretty common to feel compassion about that person if you are in a hospital or a doctor's office or some other place like that. And you think, well, we're all in this together and I can talk about this. But no, that's not appropriate. We'll talk about this a little bit later. Don't get mad because someone requests a reasonable accommodation. They have the right to do that under the ADA, and they also have the right to do that in circumstances under the PDA. So we need to be thoughtful about these approaches and not make knee-jerk reactions. This is one of my favorites. Some of you are probably wondering about that. What? Yes, just like I said it on the slide. Don't FBI HR about why someone is on FMLA leave. Many of you on this call today probably can relate to that very well. You can relate to the fact that a manager has come into your office and they really, really want to know why someone's out. and they really, really, really think that you really, really need to tell them in all the great details. That does not happen that way. The FMLA and the ADA have confidentiality provisions that go with them. And how that information is communicated in the workplace must be kept confidential. It must be on a need-to-know basis. So if you're in HR, go ahead and basically tell that person, you know what? That's none of your business. I think that's a professional thing you can tell them. The same thing is don't FBI HR about why someone needs an accommodation under the ADA. Now, this brings up a common thing that people often ask about. What do you do if you have some employees that see that someone is absent or that see that someone is perhaps taking leave and doing things that they think are not working toward their job? How do you handle that? Well, I think the first thing that you do is to be very candid with those employees and tell them, look, focus on your job. Well, we have duties here to accommodate individuals for medical conditions all over this organization, and we don't discuss what goes on with other employees. I'll tell you another story about how you can articulate this in training when you do employee training. Here's the story. There was an employee who worked at this organization, and he was going home earlies on Wednesdays and Fridays. And this had been going on for about a 6-week period. The people on his shift were getting very frustrated with him, and they were saying things like, you know, he's just getting away with murder, and he must be somebody's favorite on the shift leader and all of that. And they were actually getting to a point where they were being very rude to this person and making derogatory comments to them. Well, what happened was about 2 months after that, he passed away. And they were shocked to find out that the reason why he had been going home early on Wednesdays and Fridays was because he had been going down to MD Anderson Cancer Center in Houston to get last-ditch chemotherapy for stage 4 prostate cancer. And what was the company doing? They were providing him with a reasonable accommodation, and they were maintaining the confidentiality of that. So sometimes it's just a very candid conversation that you have to have with employees. And it's simply this. You know what? We're not going to talk about everybody's confidential medical information. And if you were in this situation, I'm confident you would not want us to be talking about yours. So this is some of the things or some of the very practical things that we can talk about. Here's another one. And this one can have overlays on the Americans with Disabilities Act. You may have someone that's out on FMLA leave. Well, the reason why they're out is because they have a serious health condition. As we'll talk about in a moment, the reason why they're out is because they are unable to perform the functions of the job. That being the case, why would we have folks calling someone while they're on FMLA leave? That could be particularly troublesome when the person who's making those phone calls is a manager and the person is an employee. You know, the appearance that creates with that employee is one that maybe a manager does not intend to have. The same kind of thing can happen under the ADA. Maybe you have an employee that's been granted an accommodation and leave is part of that. And really, the last thing that they need to hear is that manager constantly calling them and asking them about their medical condition once they've already provided the information to the company that justifies and substantiates their need for leave. So these are some of the kinds of things that the practical points that we need to be thinking about when we talk about these laws. Manage the managers. Now, this is something that not a lot of managers or HR professionals know. The FMLA was titled, and it's sourced from the Fair Labor Standards Act, the FLSA.
Because of those two statutes, always know that of the federal statutes, these two impose personal liability for violations of the law, the FMLA and the FLSA. And what this means is this, that even if it was an inadvertent kind of a situation, liability still exists. That is one of the most important reasons why training is so important for managers and supervisors, so that they understand what their responsibilities are. For those of you in HR, this can also be a wake-up call to the extent that you get into the process of evaluating someone's need for leave, and maybe you haven't done the onion peel that's necessary to administer the certification forms under the DOL. Now, here's the thing. Is there individual liability under the ADA, Title VII, or the Pregnancy Discrimination Act? No, there is not. But it's a kind of a tough course to navigate through when you talk about how the interplay of those acts go together. Now, let's talk about covered employers. This is an important distinction because we have covered employers and covered employees. May I ask a favor, please? I'm hearing some feedback from someone's microphone. If you are not on mute, there you go, fix that. All right, the FMLA, covered employers, 50 or more employees, okay? This includes part-time, temps, and full-time employees. It also, in certain circumstances, may include seasonal employees. The ADA and Title VII cover 15 or more employees. And again, this includes temps, part-time, and full-time employees. Now look, where you see below on the slide here is where the intersection comes for employer coverage. So employers that have 50 or more employees are going to be covered jointly and concurrently by the FMLA, the ADA, and Title VII. Now that's very important because here's the thing. You may be a small employer. You may not be covered by the FMLA, but you may have a duty to provide leave as an accommodation under the ADA or under Title VII under the provisions of the Pregnancy Discrimination Act. So we do want to talk about that a little bit greater detail. Now, let's talk about just a general overview of the FMLA. An employee may take up to 12 weeks of unpaid leave for the birth or adoption of a child, the serious health condition of that employee or a member of their immediate family, a qualifying exigency need, and I always get tongue-tied when I say that, but it's for military deployment leave, and military caregiver leave. Now, I want also to talk about something because I also want everybody to remember this. In March of 2020, Congress passed the Emergency Family Leave Act, the EFMLEA. And many employers still think that the EFMLEA is still in place. It is not. It expired on December 31st, 2020. So if you hear people talking about that and talking about the leave requirements for up to 2 weeks of unpaid leave for conditions like being unable to provide childcare or being unable to telework or work because of childcare requirements. So those statutes or that part of the FMLA has not been renewed. So I just want to remind folks of that. The other thing I want to point out is this 12 weeks is in a 12-month period. And the FMLA has 4 different ways that that 12-month period can be calculated. You can get more information about that by going to the Department of Labor's website, www.dol.gov. go to the wage and hour division, and you can click on the section for the Family and Medical Leave Act and find more information about that. Now, what is the difference between eligibility under the ADA and the FMLA? Well, here's the thing. An employee under the ADA needs leave because of their own disability, but it's different under the FMLA. In that circumstance, the employee is taking leave for their own serious health condition or a member of their immediate family. And it's a different kind of looking at this. So where you have these two statutes overlap is where you have an employee who needs leave for their own medical condition. Now, here's the thing that's very important. The duty to accommodate is to the employee. You may have an employee who is taking care of a member of their immediate family for that family member's serious health condition. That will not trigger a duty to accommodate under the ADA. So the duty to accommodate under the ADA is only for that employee and that employee's disability. A lot of times people get confused about that. And the reason why that is important is because under Title VII and under the ADA, we have caregiver responsibilities. And those caregiver responsibilities are something that the EEOC also enforces under its other statutes as well. When we talk about caregivers, we talk about women who are caregivers for their children. We talk about fathers who are caregivers for perhaps a disabled person in their home or another member of their family. And the statutes prohibit discrimination against caregivers for those responsibilities. But in those instances, it's not going to be a duty to accommodate leave for that. So those are some of the kinds of nuances that we also need to understand. Now, the EEOC has some wonderful information for employers about this. At the end of the presentation, I've provided you with links, but one of them right now that you can go to is go to the EEOC's website, www.eeoc.gov, and you will find a guidance there for caregiver responsibilities. You'll also find questions and answers for employers about caregiving responsibilities. Now let's talk about job protection, the ADA versus the FMLA. One of the things that is an important distinction here, and we're going to really drill down on this in just a minute, job security under the FMLA is directly tied to the fact that the employee cannot perform the essential functions of his or her position. That is a big distinction. So think about that. They cannot perform the essential functions of their position. That is in the regulations. On the other hand, the ADA is different. It protects the job security of someone who can perform the essential functions of the job with or without reasonable accommodation. So you have a situation here where under the FMLA, there is job protection because someone is unable to perform, but under the ADA, the person is able to perform, but they can do so with a reasonable accommodation. Now, why is that important? Under the FMLA, the duty to maintain someone's job and their health benefits only lasts for that 12-week period. And at the end of that 12-week period, or at the end of the expiration of that person's leave, that employee is entitled to be restored to the same or substantially equivalent job and to have their health insurance benefits continued through that time period. You don't have that situation under the ADA. There's not a provision for job restoration because people haven't left their job. There's not a provision for putting someone back in a substantially equivalent position because the accommodation that the employer may have provided is simply a reassignment of certain functions of that person's job. So it's an important distinction to make because when we talk about in a moment what essential functions of the job are and what they should be, this is a critical distinction to make. Now let's talk about eligibility. Here's another thing and another area to watch out for, and it's an area that is a common one that employers kind of get tripped up on. The eligibility requirements for the FMLA are this: the employee must have worked 1,250 hours in the preceding 12-month period. So there is an eligibility requirement and an employer coverage requirement. You have to have those two things together. The ADA, on the other hand, doesn't have that requirement. Now, what this means is this. Think about this for a second. If you have a new employee that has come on the job, but they have not worked the 1,250 hours in that 12-month period, and if they have a medical condition, they would not be eligible for FMLA leave. However, they would be, as a reasonable accommodation, eligible for leave under the ADA. That leave would be unpaid. The other thing I wanted to mention a second ago, always remember that the FMLA is a floor. It's not a ceiling. So at the floor, FMLA leave is unpaid. Many companies, though, have policies that they allow employees to substitute paid for unpaid leave. So you'll see a lot of situations where an employee may be able to use sick leave, PTO, vacation, short-term disability, or other types of leaves like that. And many companies will oftentimes have those leaves run concurrently. In other words, they all run together at the same time. Leave under the ADA, though, is different, and it is unpaid leave. So it's important to make that distinction. Now, there's no eligibility requirements under the ADA. Applicants are covered. Everyone's covered from their first day of work. What's important, though, about this for the ADA purposes is this. And I want to remind employers about this, particularly right now in this remote work environment, that employers have an obligation to provide reasonable accommodation to job applicants. What does that mean? Well, it means this. Make sure that your websites are accessible for those who are hearing impaired or who have visual impairments so that they can be able to apply for a job in this remote work environment. Make sure that whatever pre-employment materials that you have, testing materials and things of that nature, are accessible to individuals. You also, as an employer under the ADA, have a duty to provide an accommodation for someone to go through the application process itself. That might mean, for example, providing materials for someone who has a visual impairment in a manner that they can read. It may be providing those materials in Braille, or it may be providing other assistive devices for that person to be able to read these materials. That's an area that a lot of employers forget about. They do, and they get past the point of understanding that there's questions you can and cannot ask in an interview about the ADA, but they forget about the duty to accommodate in the process itself of even applying for the job. Now, here's the deal. The ADA doesn't automatically create an entitlement to time off, as you see under the FMLA when people meet the eligibility requirements. But what it does mean is this. Under the ADA, an employer may provide an effective accommodation that would allow that employee to stay on the job rather than and in lieu of taking time off. And from the EEOC standpoint, that's actually the best alternative to look for. So when we look at tiers of accommodation, we start with tier 1 of making sure that the accommodation on the job is made in and of itself. Then tier 2 would be moving toward what types of leave and what types of leave policies does that employer have for that employee. So that would include things like the FMLA, obviously PTO, vacation policies, and that nature. And once those leave policies are expired, then you get into tier 4, which is what kinds of accommodations would be acceptable, reasonable in these kinds of circumstances. So this is some of the kinds of processes of employers needing to understand. And I think one of the points, one of the key takeaways here is to know that you never look at the FMLA in a vacuum. And you don't look at the ADA in a vacuum. Anytime you have those two statutes, always be thinking how they interplay and overlap. And they do a lot through the various processes of how someone can move through their particular medical condition or their disability. Now, employer policies and ADA accommodation. An employer must provide unpaid leave as an accommodation, even if it doesn't offer leave as an employee benefit, and even if that employee is not eligible for leave under that employer's policy, and even if the employee has exhausted the leave that that employer provides as benefits. So the Americans with Disabilities Act does not require the employer to provide paid leave beyond what is necessary under the statute. The reason why this is important, and this can be very, very confusing at times, is understanding at what point do the paid leave provisions and the unpaid leave provisions get triggered. One of the things that we'll talk about in a little bit is this. After the end of the FMLA 12-week period, after the expiration of that time period, if you have a situation where an employee is unable to return to work and be restored to their substantially equivalent position, don't make an automatic decision to terminate that employee's position. The EEOC has taken the position that an employer has an obligation and a duty to engage in the interactive process. That means having a discussion with that employee to see if additional leave on top of FMLA leave is necessary. Now, understand, that does not mean that that leave is paid, but it does mean that that job is still there for that employee. The leave is unpaid. So we'll talk a little bit in a moment about what are the parameters of that, and is that just a blanket requirement under the ADA? What are the limitations on that? There's been a lot of discussion about that. There's been some case law on that, so we'll talk about that too. Now, let's take an overview for a moment of the Americans with Disabilities Act. And many of you also know that this includes the ADAAA, the Americans with Disability Act amendments. Basically, the ADA prohibits discrimination against a qualified individual with a disability who can perform the essential functions of the job with or without reasonable accommodation. Now, one of the things that people sometimes still talk about is who is and what is a disability. A disability is a physical or mental impairment that substantially limits one or more major life activities. But the real thing and the easiest thing to do today is most of the things that are that limit major life activities are going to be disabilities. So the expansion and the definition is broad. Really, from a practical standpoint, I actually like to use it this way. What does the ADAAA mean? Assume a disability and attempt to accommodate. There's going to be very, very rare circumstances today after the case law and after the ADAAA was amended where a condition is not going to be considered a disability. The other thing I want you to think about is this. We mentioned a serious health condition of an employee under the FMLA. Most things that are going to be disabilities under the ADA would also qualify as a serious health condition under the FMLA. And that's an important distinction to make and to understand because it influences things like intermittent leave, restoration of job duties, reassignment or transfer of leave. We'll talk about that too in a minute. Let's talk a little bit about the Pregnancy Discrimination Act. Sometimes people keep this act and they don't realize that it actually is an amendment of Title VII. Basically, what it prohibits is discrimination based on pregnancy, current, past, potential, childbirth, or any related medical condition. So the law requires pregnant employees to be treated in the same manner as others who are similar in their ability or inability to work. The basic, most just bottom line way to think about this is simply this. Do not treat pregnancy any differently than you would any other medical condition. Now, the EEOC issued guidance back in 2015 on leave as accommodation for pregnancy-related medical conditions. Pregnant employees may be entitled to an accommodation for pregnancy-related conditions if for other medical conditions that are not caused by pregnancy. I'll give you a quick example of this, and we'll talk about this in a little bit different detail in a moment. Many companies have light duty policies, and some of these policies are there for employees returning to work under workers' comp situations or as a result of on-the-job injuries. And what companies traditionally have done is they've wanted to encourage employees to come back and take light duty jobs because it's less expense to the employer. Well, we've had a Supreme Court decision that has come out of a situation where an employer had such a policy, but would not provide light duty to pregnant women who had complications from pregnancy. And the court said basically this: when you are carving out pregnancy and not providing similar types of accommodation, that is discrimination on the basis of sex. So in the EEOC's policy guidance about this, the guidance spends a great deal of time discussing these kinds of conditions and what could be the triggers that would provide a duty to have a discussion in the interactive process to see what kind of accommodation would be necessary. Now let's talk about how it all intersects when we talk about pregnancy. Remember this, pregnancy in and of itself is not an impairment. Pregnancy-related medical conditions may be impairments if they substantially limit a major life activity. And in those cases, an employee may be entitled to reasonable accommodation unless an undue hardship exists. Now, here's the thing, and this is something very important to know about the nuance of the FMLA. Complications from pregnancy can qualify as a serious health condition. But I want you to think about this example. I mentioned to you a moment ago that the 12-week period in a 12-month time frame is the maximum amount of time that someone can take for FMLA for the birth of a child. You can have situations where someone has complications from pregnancy and she may use all of that 12-week period before the child is born. In that situation, when she has the baby, does that mean she automatically gets an additional 12 weeks of leave? No, it's only 12 weeks in that 12-month period. However, if the child is born and she still has complications from that birth, she would be, under the ADA, entitled to a reasonable accommodation of additional leave. So do you see where that nuance comes in? And oftentimes understanding and navigating through that is going to be very important. It's very important in these situations not to make a knee-jerk reaction by automatically terminating someone or automatically reassigning someone to a different position without first examining what that duty to accommodate means, particularly the timing of that decision. Now, many of you on here, as I've heard when we started our call, are from many states. One of the things that's very, very important to know about this is the FMLA, as I mentioned, is a floor. And the regulations provide that states may have more expansive provisions and more benefits than what the FMLA entitles. That is also true for employers. Employers can have more generous leave laws than what the FMLA provides. But as you look at the states here, please note that many of these states are now expanding and have paid family and medical leave benefits and paid family medical leave laws that impose greater requirements than the FMLA does. In those instances, those state laws will prevail over the FMLA. The other thing, and this is particularly true as a result of COVID-19, that there are many state and local jurisdictions that have passed sick leave requirements that are unique to these kinds of situations that we're talking about. So some of these local ordinances and jurisdictions not only provide paid sick time off for the employee's health condition, but they also provide paid time off for the employer's family member and their health condition. So when you're looking at this, understand that you're going to have to analyze this from a multi-layered approach. It's not only going to be the FMLA, it's going to be the ADA, it will be a state paid leave law or local ordinance, in addition to a state anti-discrimination law that has prohibitions against discrimination on the basis of pregnancy. So it's kind of a murky water that can go through there, but you can swim through it if you're kind of navigating and are cognizant of how these different laws can intersect. Let's talk about workers' comp laws for a second. Now, the thing about workers' comp is this. Workers' comp is not a leave statute. It is time off from work pursuant to a state compensation statute for an injury. And that's a different purpose for what the FMLA was enacted. So most states recognize claims for workers' comp and workers' comp retaliation. And workers' comp leave can also affect employees' benefits leave. But the determination of benefits under workers' comp statutes is not the same determination of benefits and pay under the FMLA. So that's a very important distinction to make. The other thing to be mindful of is this. Many employers will allow FMLA to be run concurrently with workers' comp. And they do that to make sure that both of those leaves are running at the same time, ostensibly to make sure that employers are provided with their rights. So you may have situations in some circumstances where someone may still be on workers' compensation, but their FMLA leave has expired. Here's something that's very important to know. And I want to give you an example of where the intersection of this can occur in the workplace. Workers' comp retaliation. Many states, if not most states, have retaliation laws. But let's talk about how that can show up in the workplace and why it could be a problem with the Americans with Disabilities Act and the Family Medical Leave Act. Let me give you an example. A company has a peer hiring team, a peer review team that not only looks at hiring, but they also look at promotions. So we had a situation a while back where this manager is applying for a promotion, and he goes through a peer review process to do that. During the discussion of the peer review team, one of the managers said this: I'm not going to have anybody on my team that's ever filed a workers' comp claim against this company. And what had happened was this particular manager the year before had been out on workers' comp for a shoulder injury that he received at work. Well, think about that. That not only is a workers' comp retaliation issue, to the extent that this fellow was out on FMLA leave, that's also an FMLA retaliation claim. To the extent that he had a need for reasonable accommodation under the ADA, that's also an issue as well. You know, an argument in that situation could be that the company regarded him as being disabled as a result of that injury. So the whole point of this discussion is this: all of these things cannot be evaluated in a vacuum. The other thing is this: when companies are having these kinds of meetings and they're talking about these kinds of issues, they need to be very cautious of what is being discussed in those meetings. Here's another example. Many of you might have seen this. Let's say you have a bunch of folks that come in and they're getting ready to sit down for a meeting in a conference room. Actually, it could even be a Teams call. And someone just innocuously says, you know, where's Jim? I thought he was going to be on this call today, or I thought he was going to be in this meeting. And someone pipes in, I think he's out for his back surgery. As a matter of fact, I don't think he's supposed to be back till the end of July. Really? Well, what's wrong with his back? That whole conversation, even among the management team, was a problem. First of all, no one in that meeting and no one in that room should have been discussing this person's back or the fact that this person was on leave. The only thing that somebody should have ever said in response to that whole conversation is simply this: he's out on leave. You don't say he's out on sick leave. You don't say he's out on FMLA leave. You don't say, well, he's out because he was given an accommodation. No. So even among members of the management team, how they discuss these kinds of situations is very, very important. And it's very important to keep that information confidential. While I'm at it, let's talk about confidential information. This is a question that often comes up. Can we store that stuff somewhere? Where do we put stuff like the FMLA information? Where do we put workers' comp injury reports? What do we do with the ADA reasonable accommodation requests that we get in? You can put all of that information in a separate confidential medical file that needs to be secured someplace. You don't have to segregate it out. I mean, you can if you want to. But what you don't want is this. You don't want any of that kind of information in someone's personnel file. And here's why. Let's say, for example, and let's use another example about this. You have a manager that is looking through somebody's personnel file and sees that employee has made a request for accommodation. And maybe, let's crank it up a notch, that request for accommodation was time off from work because this employee had a psychiatric condition. Let's say, and take it a little farther, that the psychiatric condition that he had required him to have an extra time to come into work in the morning. So he takes medication for his psychiatric condition. It leaves him groggy in the morning. He asked for and got a reasonable accommodation to move his start time an hour later in the morning. Would a manager need to know that information by looking through someone's personnel file? Absolutely not. So things like that, requests for FMLA leave, requests for transfers, all of those kinds of information need to be kept in a separate file. The other thing that I want to mention is this. And a lot of times employers they don't think about this, and they don't think about how other people see information as it's disseminated. Let me give you an example. There are a lot of times, for example, let's say I'll take a warehouse facility. And there are instances where employers may have logs out and employees go and they sign in and they sign out of a log. It would not be appropriate for an employer to have a log which reflects employees who mark off if they're going to be sick or they're going to be out on some kind of medical leave. And the reason for that is that information needs to be kept confidential. So it's one thing for someone to just, clock in and clock out and do something like that, but it's entirely another thing for someone else and other coworkers to go and look on that log and see that someone's out for surgery or a workers' comp injury or something like that. So that can be another problem. Let's talk about another issue that sometimes comes up. I've actually seen this a couple of times. Many organizations have safety, health, and SHE, safety, health, and environment positions. And a lot of times, the person that's in that position may be the person who is overseeing safety injuries, workers' comp injuries, and things of that nature. You may have a situation where that employee needs to go and see the doctor for a workers' comp claim or something like that. Here's a case that I had actually before I came to the commission. So we had a situation where the SHE coordinator was driving the employees to the doctor's appointments. So she'd drive the person to the appointment, they would go in the waiting room, and when the employee was called in to see the doctor, the SHE person went in with him. So she actually sat in the room with him, with the doctor, as he was asking the employee questions about his injury and this and that and stuff like that. And it took quite a bit of discussion with the company to make them realize that that was a huge violation of the Americans with Disabilities Act. That SHE person should not have been sitting in that room while the doctor asked those employees questions about his medical condition that had nothing to do with his workers' comp injury. So, for example, he might have been asking the employee how his blood pressure was doing or how his diabetes was doing. Those kinds of discussions were appropriate, but not with her sitting there. So we had to remedy that and basically ask her, if you want to drive them over there and drop them off and wait in your car, that's one thing. But don't sit in those meetings with the employee while they're having conversations with their healthcare provider. So those are some of the kinds of things that employers need to be thinking about and how they implement their workers' comp policies and how those workers' comp issues can quickly turn into an ADA issue. Another question that oftentimes come up, which is an intersection of workers' comp and the ADA. What should companies do when there has been a work injury? And many times what companies do in that situation, they may have safety meetings to have a debrief about whatever the safety procedures are or whatever the occurrences were to make sure that employees are following procedures so injuries like that don't happen in the future. Can an employer or can a supervisor in that meeting go into great detail about this employee and the injury? No. Could the employer, though, talk about the circumstances that caused the injury? Yes. But that's a different way of talking about it rather than identifying this employee and sharing potentially more information than is necessary to address and discuss the safety issue. So again, that's another example where understanding these nuances of how these laws intersect are very, very important. Let's talk about something that's dear to my heart, job descriptions. Now, one of the things that I have over the years, I've had many organizations, I've had many managers tell me that they don't want a job description. They just don't want them. We don't want them. We don't want to do them because we don't want to put anything in writing. Well, my pushback to that has always been this. If you don't have a job description, how do people know what it is they're supposed to be doing? How would you evaluate performance? How do you set any kind of metrics? How do you figure out what you need to do if you need to provide a reasonable accommodation? That is very, very difficult to do in the absence of a job description or a position description. So one of the things that it's very helpful to do is to do all these things. People want to know how they're doing. And in order for them to do that, they want to know what their performance requirements are. Having a job description is essential to determine what are the parameters of reasonable accommodation. How do we go about restructuring the job? And from the standpoint of the FMLA, one of the things that the Department of Labor did just recently, because they updated their wage and hour form 380E, that form is the certification of physician form for the employee's own serious health condition. And one of the things that they did is they have on there, check if an employee's essential job functions and check if the job description is attached. So it's an important thing. Now, let me kind of give you an overview of why the job description is so important for an organizational management standpoint. And I want you to think about for a moment the entire 360 of the working environment, from the beginning of the employment relationship all the way around to the end. So let's go through this exercise for just a moment. And I want to demonstrate to you how many times a job description is critical to how an organization can have uniform and consistent application of its policies and how it can have legitimate and non-discriminatory business reasons for the decisions that it makes. So let's take the first example. The first place that it would be great to have a job description is when you interview someone or hire someone. How many times have you seen a situation where a manager has shown the applicant in the interview the job description? And oftentimes people tell me, well, Kat, I don't need to do that. It was posted on the internet. Well, how do you know that they read it? Well, they have the acknowledgement form. How do you know that they understood it? What if on your system at your company, you don't have the full job description, you just have a summary of it? One consider a good best practice is to show the applicant the job description and go down with them piece by piece by piece. That is a good thing to do. Another place where you can use the job description is to tailor your recruiting. If you have the job description and you have the parameters there, you can have targeted recruiting and understand that you will have applicants in your applicant pool that are tied to the criteria in that job. So that's a place where that job description can be very, very critical. The next place you can use a job description. Think about this. Anytime you want to have promotions, demotions, or transfers. Now think about this. How many times have you promoted someone to a position? Did you show them the job description for that new promoted position? Did you go over it with them? Did you have them acknowledge that they received it? If not, why not? Because if you're promoting someone to a new position, you now have established different performance metrics because that is a different job description than the job that they originally had. The same thing would go for someone who you decided to transfer or someone who you maybe needed to decide that they needed a demotion. That job description is critical in that inquiry. The next place you're going to see it is when companies have job postings and they have internal job postings. And you'll see situations like this. And many of you who are out there in HR land will know this. How many times have you seen instances in an organization where a company has posted a job, but they've already picked out who they want for that position? And in many of those circumstances, sometimes the person that they pick did not meet the posted requirements. And sometimes in that situation, the posted requirements had nothing to do with the job description. That can be an issue. The next time you could use a job description, at any time you're going to do performance evaluations. And this would be very, very important in a situation where someone has been out on leave. Maybe their performance metrics have changed during that time. So sitting down and looking at a job description at the same time you're doing a performance evaluation would be a pretty good thing, right? You'd be amazed at how many people don't do that. My question in that situation is this: how can you evaluate performance in the absence of looking at the job description? Because there may be times throughout that year that some of the functions in that job have changed. And when you think about what that could look like under the ADA and a reasonable accommodation, that job description and some of those marginal functions in that position may have been reassigned to someone else. That would be a good time in that conversation to discuss that. The next time that would be a great place for the use of a job description is in any kind of disciplinary write-up. Oftentimes, employers don't follow the best practice of attaching perhaps or stapling a copy of the job description and maybe perhaps the policy that was violated to the actual write-up. It makes a whole bunch more connected sense if someone can say, okay, now I know what I was written up for, and I know now what it was in the job that I wasn't doing. The next time, that's a very good place to have a job description, is anytime you're considering decisions about compensation and benefits. One of the things and one of the strategic priorities of the Commission will be looking at pay equity and focusing on the Equal Pay Act. The 60th anniversary of the Equal Pay Act is coming up in 2023. So looking at things like that are going to be important. The last place a job description would be important is in the decision to terminate someone's employment. And basically, it's actually very common sense. Having a job description will allow you to make the decision and the conclusion of why are you terminating that person. So I've just demonstrated to you there how many places you can use a job description effectively, and take that example and think about how those situations could come up in a situation where you're providing a reasonable accommodation. How could those situations come up when you are looking at restoring someone back from FMLA leave, or perhaps transferring someone for intermittent or reduced FMLA leave? So that job description can be very, very important to that process. Now, does the FMLA require job descriptions? No, they don't. But one of the things that I think is very interesting about the revised wage and hour 380E form is that last sentence there, and I'll read it to you because this is brand new. they say that the essential functions of the employee's position are determined with reference to the position the employee held at the time the employee notified the employer of the need for leave or the leave started, whichever is earlier. That is very important, because what that means is this: the essential functions that the employee is saying that they are now unable to perform under the FMLA are tied to the job they currently have, not a position description that is an old job, not a position description that is from a transfer job, but the position that they have right then and there. So what's going to be important is this: what were the essential functions of that job at that snapshot in time? And this, again, is another area where employers can kind of get themselves in trouble, because they may do things like, well, not have a job description. We already talked about that. Or they might have a situation where they have a job description that's 15 years old. Or they may have a situation, and this is a more common problem, where they have a job description and it doesn't have all of the functions in it. Or they have a job description and they have crammed a whole bunch of tasks into that phrase, other duties as described. But when you're looking at this from an FMLA standpoint, and we'll talk about how that has a direct impact under an ADA analysis, having a current job description that accurately reflects that person's duties is absolutely critical to the analysis. Now, how about this one? Does the ADA require job descriptions? No, it does not. All it requires is that applicants and employees are able to perform the essential functions of the job with or without reasonable accommodation. But here's the thing. During an investigation, one of the things that the EEOC will look at is what are those essential job functions and what are those job descriptions that the employer had when they're advertising a job? And does the job description actually match what that employee is doing? So in this context of this discussion, understand that the ADA does not prohibit an employer from changing a job description or adding functions or moving functions to someone else. But what it does require is that someone's disability and their qualifications are evaluated in relation to and in conjunction with those essential functions. So one of the things employers need to be mindful of are doing things like adding functions to a job description and not telling the employee about it, or measuring performance of an employee on tasks that they don't do in the job description at all. So that could be another problem. And we're going to talk about in a second how that really gets tangled with the ADA. So now let's look at this together. Job performance with the FMLA and the ADA. Before, a serious health condition makes the employee unable to perform the functions of the job. But it's also meaning that the functions that they are unable to perform are essential functions to that position. Notice that the categorization of the word and the definition of the word is essential functions. On that wage and hour form, it doesn't say marginal functions, okay? That is important for purposes of the ADA as well. Jobs need to be classified with a delineation between essential functions and marginal functions. So this is something that I think a lot of employers miss when they are looking at this analysis of these jobs, particularly when they're thinking about, how do I have a fitness for duty and what does that look like for someone on a return to work situation? Now, what are some best practices in creating job descriptions? Well, the first thing is put the wording for the time required for each task that needs to be performed. If this particular task takes an hour or takes 3 hours or whatever that time frame is, be specific as you can. The other thing is have wording in the description that describes the physical demands of the job, the general and specific. So perhaps you may have a job, even in an office position, that would have a function that requires someone to bend, stoop, or lift. Maybe you have a lifting requirement in there of 10 pounds, or maybe the job requires a 50-pound lifting requirement, depending on what that particular job is. The other thing you want to do is to describe the general and specific mental demands of the job. And that's an area that employers often overlook when they are creating job descriptions. They put all of the physical demands, but they don't put anything of the specific mental demands. So having things like verbal intelligence, motor coordination skills, comprehension, organization, decision-making skills would be an important part of that job. You also want to make sure that you describe the working environmental conditions. Is this job in an air-conditioned facility? Is this job in a facility where there's, extreme temperature changes, or maybe out in a warehouse facility where they're outdoors? Things of those natures. Now, I don't want anyone to leave here thinking, oh my gosh, I've got to have a job description that's 50 pages long. I'm not suggesting that, but I am suggesting that you sit down and have a thoughtful approach and a thoughtful discussion about what really is this job? What really is this person doing? Because if there's one thing over the years that I've seen a tremendous disconnect, is what the employee thinks that they're doing on that job most of the time doesn't match with what the manager thinks the employee is doing on that job. And when you have that cognitive disconnect between expectations, that's where you have issues where people are not happy with their performance, or they may have a perception that their performance criteria is being discriminatorily applied to them, when maybe really the issue is not that. It's the issue we're not communicating on the same page because we're not aligned with what this job actually requires. So here's some other job description tips. Don't confuse function with method, okay? You can have a job that has lots of methods to a function. So an essential function is what the completed task is, but not how it's done. So you may have, I've seen this in a lot of job descriptions. Somebody says, well, you need to walk around the office, or you need to walk from, this location at this facility to another location. Well, it's not really that they need to walk, it's that they need to move. So someone in a wheelchair could move from one place to another place. So those are some of the kinds of things that we're talking about when you're analyzing what to put in these descriptions. Always remember that for purposes of analyzing this under the ADA, the position exists to perform the function, okay? And the easiest way to kind of process through this, and I'm going to use an example of this. Let's say you have an organization that's going through a reduction in force. And it's always a good best practice to make sure that you're eliminating the position and not the person. So if you take it and apply to this situation, what that forces the employer to do is this. What is the position that we're eliminating? And what are the functions that are in that position? And if we eliminate it, where are those other functions going to go? Are they going to go to this person or that person? Or has the employer made a decision that those functions are going to be completely eliminated? That is key to what goes in a job description, so that when you're looking at functions, you can identify which ones are essential and which ones are marginal. The other thing that is oftentimes extremely helpful, and to me, I really think that this is a place where we ought to start anyway, is ask the employee what they're doing. sit down, and when you have a job analysis of, looking at what everybody's doing, and maybe you're going through a period in your organization where you're re-examining your job descriptions, ask the employee what they're doing, get their feedback. It's one thing to sit there and have one view of what they're doing and then just kind of plop a job description on their desk on a Monday morning, but it's an entirely different situation when you get their feedback. And when you get their feedback, guess what else you get to that? You get their buy-in on the performance of it, because now they know what they're going to be doing. They agree to what they're going to be doing, and it just makes a more cohesive workplace to do it that way. Now let's talk about the notice provisions of the FMLA. And this is important because this is going to be another area where you can have the ADA kind of sneak in here. There are 4 types of notice under the FMLA that are very important for employers to follow. The first is the general notice. This is DOL fact sheet number 28. You can go and download it from the DOL's website. One of the things that the DOL has said, employers may use the fact sheet as their FMLA policy in their handbook. So the next notice is the notice of eligibility. This is Wage and Hour Form 381. Now, this is an important form because, as I mentioned earlier, it tells the employee, are you eligible for leave? Have you satisfied the 1,250 hour requirement? Do you work for a covered employer within a 75-mile radius? And there's other things on that particular form. So the notice of must be provided within 5 days, and the employer must give a reason if the employee is not eligible. So in other words, when they return that form back, if there's information that's missing on there, the employer needs to have the discussion with the employee about it. The next form is Wage and Hour Form 381. This is the Notice of Rights and Responsibilities. Now, this is a very important notice because it tells the employees what their responsibilities are once the leave is designated. So there's a lot of information on there about whether or not, for example, you are going to be required, or the employer is going to require the person to have a return to work notice. How often must that employer communicate with that employee or the employee communicate with the employer, during the leave? The next thing is the notice of designation. This is the Wage and Hour Form 382. Again, this must be given to the employee within 5 business days. So you have this whole notice process going there, but let's talk about how it works, and then I'll show you where some of these other issues can pop in. So one of the things the employer wants to do is this. You want to send the notice of eligibility with the certification of physician form for that employee's serious health condition and staple the job description to that. Now think about that for a second. Once you have that information back from that physician, you have something that you can look at that can give you useful information if and when that person needs to have a reasonable accommodation. And that could be triggered for an employee who's taking intermittent leave. So that is one of the areas where the ADA can come in. So the second step is this. Once you have got that information back, designate the leave. Designate the leave. And when you designate the leave, one of the boxes that you can check off on there is that the employee will be required to submit a return to work fitness for duty note. Return to work fitness for duty notes can be required under the FMLA, but they also can be required under the ADA. The parameters and the information that the employer can seek for the ones under the FMLA are more stringent than they are under the ADA. So we'll hit that in just a second. One of the things that employers need to do is this. They've got to recognize a request for FMLA leave. Just like under the ADA, an employee does not have to come and say, I need a reasonable accommodation. So under the FMLA, they don't have to ask for the FMLA by name. They simply have to provide the employer with sufficient information and sufficient notice to put the employer on notice that they may have a condition that qualifies for leave, a serious health condition. So you may have situations where it is appropriate to train your managers to think about what an FMLA leave can sound like, because many times a request for FMLA leave is going to sound the exact same thing as a request for a need for accommodation under the ADA. So here's some things, someone might say, I think I'm going to need surgery, or I need time off. I need to take my mother. She's getting cancer treatments. That would be a conversation where somebody might need time off to care for a member of their immediate family. Or maybe you might have someone that needs time off. Maybe they need to see a therapist or something like that. Someone who's suffering from PTSD and other serious psychiatric illnesses are going to be conditions that also would qualify as a serious health condition if the person is receiving continuous treatment for a healthcare provider for more than 3 days. So there are lots of situations in there. Now think about this. Maybe you have someone with a hidden disability. In this case, the example that I'm using is a psychiatric condition that also would need accommodation under the ADA. So there may be situations, for example, where maybe they have exhausted their FMLA leave. They're still able to come to work because the FMLA leave that they used was intermittent leave. It wasn't in leave in big chunks, but now they have exhausted the intermittent FMLA leave, but they still need intermittent leave to get therapy for the psychiatric condition. In that example, that would trigger a duty for an accommodation. So do you see how these two things can be wound together like that? And again, that's why it's so important for employers not to have this myopic view of how they're looking at this, because at any given moment, this fact situation could shift. So here's another thing, and this is a very, very common misunderstanding with employers. FMLA, when you're talking about intermittent or reduced leave, okay, the first foundation of it is that the employee, when it's foreseeable leave, has to schedule that in a time that's convenient to the employer, okay? When it comes to leave for birth or adoption, that is only if the employer agrees, and the employee must seek and the employer must acknowledge what is the least disruptive schedule to do that. Now, here is the big one. Transfers to other positions under the FMLA can only be done in situations where the leave is foreseeable. If you have unforeseeable leave, transfers are not permitted under the FMLA. So you may have, a situation where this overlay can come in, where you have someone who's taking intermittent leave under the ADA, and it may come out of a situation because the need is unforeseeable. A situation that comes to mind would be someone who suffers from recurrent migraines. And you could see this kind of dichotomy going on where there may be a reasonable accommodation under the ADA that may go beyond the intermittent leave provisions under the FMLA. So again, sitting down and processing through what these different leaves might be and how the duty to accommodate may be triggered. Okay, so here's a big one. This should come as no surprise to folks, okay? And I deliberately put this on the slide like that. Working from home, not. Now think about this in the discussion that we've been having. By definition, the FMLA says that you are unable to perform the functions of the position. So if you're unable to perform it, then why are you performing the functions at home? And what this means is the time you're spending working at home cannot be counted as FMLA leave. It also, just so you know, must be considered as hours worked under the wage and hour laws. So we don't want employers pressuring people to work from home. But now think of this. Think of this. If the person is working from home on FMLA when they're not supposed to be, is that not really a situation where they're working from home and really what it is in essence is a reasonable accommodation? I mean, do you see how that kind of flips that way? Because that basically is what that comes down to. They really aren't on FMLA leave, but you are allowing them to continue to work as a reasonable accommodation for the time period that they have that medical condition. So again, that's one of these situations that can turn on a dime, and looking at these things on a case-by-case basis and monitoring this is going to be very important for employers. Now let's talk about fitness for duty certifications. And now let's really get into the weeds of the difference between what an employer can ask under the FMLA as opposed to what an employer can ask under the ADA for these fitness for duty certifications. Okay, here's the thing. The FMLA is more stringent. In other words, it's more narrow as to what the employers can be having discussions about. So they can only ask, for example, about the condition that caused the need for leave. They cannot ask overbroad information. And as a best practice, the employer should stay within the four corners of the certification of physician form, and they will avoid going farther into areas that they don't need to go. The fitness for duty must state that the employee is able to resume the work. So an employer under the FMLA may require a fitness for duty to perform essential functions of the job. Now, here's the thing. What's an example of this that would be an FMLA violation? Let's say that you had an employee that went out for FMLA for a back injury. Maybe they had back surgery or something like that. So the employer on the fitness for duty return to work, instead of confining their inquiry to, can you perform the essential functions of this job, which might be a lifting requirement or something like that, they may go off on a tangent and ask this person, well, how about this? Have you had, do you have diabetes? Has anything else come up in your situation? I know that they probably gave you a lot of pain medication. So, are you still on those drugs? Are there any other drugs that you might be taking? That is a conversation that would go beyond the FMLA, and that would be a violation of the FMLA. So again, staying within the corners of that. Now, the ADA allows employers a little bit more leeway on that. Under the ADA, employers can have discussions with their employees and ask for information about what you need for an accommodation and what do you need to come back. Are you able to perform these essential functions? In those situations, under the ADA, an employer could have conversations directly with that employer's doctor. That is prohibited under the FMLA. Under the FMLA, an employer may only talk to the employee's healthcare provider. That employee or the employer may not talk to that employee directly. So that's kind of how you see how that can happen. And again, that's a very important distinction to understand. Here's another big one. This is a huge one here. Under the FMLA, if you have an employee who comes back with a fitness for duty and the employer disagrees with that fitness for duty or what that physician says, under the FMLA, that employer is prohibited from getting a second opinion. They're also prohibited from getting a third opinion. Now, that is something that is unique only to the FMLA. So here's what happens from the FMLA side of the house. If you have someone that comes back and you suspect that that fitness for duty is, not accurate, or there's some information missing, or perhaps it doesn't really reflect realistically what this person is doing, then what you would from an FMLA standpoint do is you would address whatever those issues were as a performance issue and not as an FMLA medical issue. So again, one of the best things to do here is have the job description, because what you can do from the FMLA side of the house is right before this employee is scheduled to return to work, send the job description to the employee and tell them, you know what, you've got to send this on to your healthcare provider and they need to look at it because they need to make sure that when you come back, you can do the essential functions that's listed on this job description. That would be a good best practice to do. So here's the other thing. Under the ADA, could you go for a second opinion? Sure, because you're outside of this. And the interactive process is a discussion that the employer is having directly with that employee about their need for accommodation. So there will be lots of times when an employer may get a second opinion, or maybe it's flipped around. Maybe it's employee who's getting a second opinion to provide more information to that employer to determine the scope of the accommodation and what that accommodation may need to look like. Let's talk now about maximum leave policies. And this is something that I'm sure everyone has known for some time. Facially neutral maximum leave policies may create a liability under the Americans with Disabilities Act. So here's where this is very important. The FMLA job protection ends at the expiration of that 12-week period. Now, there may be situations where an employer may have more generous leave policies and that employee still is on the payroll because they may be using things like sick time or PTO time, particularly if they have, more than 12 weeks of time, but they still have their job. But at some point, when all of that leave expires, there still will be a duty under the ADA to make a reasonable accommodation and to engage in that interactive process and do that. So that's why it is very important that managers are trained not to make an automatic knee-jerk reaction and terminate at the end of that FMLA period. Here's another best practice. Train managers also not to make a knee-jerk reaction and terminate someone after a 3-day absence under a no-call or no-show policy. And here's why. There may be situations where the reason why that person has not called in is because maybe they're in the hospital, or maybe they have a condition and someone in their family has not been able to contact the employer. Or it could even be a situation absent an FMLA thing where an employee simply needs an accommodation, but they haven't yet had the ability to talk to the employer and talk about that. So again, these are situations where practicing the pause is a very good tip for employers. Step back, assess the situation, and then determine what you need to do. You may at the end of the day, get to get through the ADA, you've navigated through the FMLA, and you've navigated through the Pregnancy Discrimination Act before you make that termination decision. And that as you've gone through this process, that you've documented what you've done, because that is the other critical piece that many employers miss on the situation. They'll get that certification form filled out, but they don't follow it up with any documentation to the employee. They might begin the discussion about the interactive process, but it's not documented anywhere. And maybe the discussion gets dropped off into a hole somewhere and no one ever comes back. But the point of it is there's nothing. There's no documentation of what efforts the employer took or the employee requested for an accommodation under the ADA or a need for leave under the FMLA. Let's talk a little bit now about light duty. This is a huge, huge thing. Now, light duty is typically something that you will see with workers' comp in that context. So the workers' comp carrier, oftentimes when they have consulted with the treating physician, will recommend light duty. Companies oftentimes want to get employees back to light duty, again, because it's a lot cheaper to do that, and it's actually, studies have shown it's better for the employee. But now let's talk about light duty and how it works with the ADA and the FMLA. First off, the FMLA does not require light duty. If an employer chooses to have light duty, they can't force the employee to accept that. In other words, they can't tell the employee, look, you have to come and have light duty. You can't stay out on leave. That is a violation of the FMLA. If the employee does accept light duty, it cannot be counted toward their 12-week leave entitlement. Now that should make sense, but you'd be amazed at how many employers mess that up. But think about it for a second. If the person is on light duty, they're working. So they don't meet the definition of unable to perform the essential functions of the job. And that is why it's not counted toward their FMLA leave entitlement. But now let's talk about it from the ADA standpoint. Back when the ADA was way back when, it was enacted in 1990. And I believe in 1992, the EEOC issued its technical assistance manual for the ADA. At that time, and is still the case, the ADA does not require employers to offer light duty jobs or to create light duty positions. If the employer chooses to do so, they can do that. But they have to make sure that in the administration of these light duty policies, that they don't have a disparate impact on pregnant employees. And that goes back to what I was talking about a little bit earlier when I was mentioning how the duty to accommodate complications from pregnancy can arise under the ADA. And oftentimes it can be an accommodation of light duty. Now, here's another best practice for employers. Sometimes employers get stuck on light duty positions. And the problem with that is this. If you have somebody that comes back to a light duty position and you leave them there, you basically, in essence, have created a job. Now think about this. And I know some of you out there will have a chuckle about this. How many of you have folks at your organization that have been in a light duty position for 5 years? Yes. And is that really light duty anymore? Actually, it's kind of a permanent position. And not only have you created a permanent position, to the extent that that person is in that job, you've now actually defined the essential functions of that position. So they've now been performing it. So here's something that you could consider as an employer. If you're going to have a light duty position, make sure that it's for a temporary time. A lot of employers sometimes choose these things to be maybe 30 days, maybe 60 days. Or alternatively, maybe instead of using a light duty position, you could focus on light duty work. And this person is doing light duty work for a certain time period. Now, what is that going to presuppose? One, that you're using a job description so that you can figure out what parts of this position that someone can do and what part is going to be set aside for a time for while they're doing light duty in this temporary position. So here's the thing, and this is a very important piece here, directly tied to the ADA. If you have someone in a light duty position or they're doing light duty work, and after the end of that time period that you have established for that light duty work, they cannot go back and do the original functions of their job, then you are in a different place as to figure out what you're going to do. Because at that point, where you're at is this person is unable to perform the essential functions of the job with or without reasonable accommodation. And what you have done in that situation is by offering light duty, you have provided them with that accommodation. You see how that works? So when an employer gets to that point, I think it is very important for them to analyze, well, what do we do? Do we reassign someone? What does that look like? Reassignment can be a valid option under the ADA as long as where you're reassigning that person to, if you're going to reassignment to, like, let's say a vacant position, that person has to be qualified for that vacant position. You can reassign someone and it does not need to be a promotion. And if you reassign someone, it does not mean that you bump someone else out of a job or you bump someone out of seniority under a collective bargaining agreement. But what it does mean is this, that the employer should look and see before they make that termination decision, are there any other open positions? And when I say look, that means look. That doesn't mean, okay, I'm just going to look on the 5th floor and I don't see any open positions. No, that is a burden that the employer must show, is that they went through a process and looked around the organization to see if there were vacant positions for which this person was qualified for. Only after you've gone through all of those processes, then you may get to the final conclusion that we have no other option but to terminate. But that should be a long process to go through. And it should be a process where you have actually engaged in the interactive process and finished it, because we're going to talk about what that looks like here in just a minute. Undue hardship. Undue hardship. Now, here's the thing. The FMLA does not have an undue hardship defense. The only thing that would probably come close to that is the key employee provision, where a key employee, because of their position, I think they're, I just lost my thought, making the top 10% in the organization with regard to salary would not be restored to their same or substantially equivalent position, but that's actually kind of a remote connection. But the ADA does have an undue burden defense. But here's the thing, from a practical standpoint today, the slope is high, I think very high, for employers to show that an accommodation is an undue burden. But these are some of the factors that an employer must consider. The nature and the cost of the accommodation. You know, a lot of accommodations that employees request are very, very, very inexpensive. A good place to go and find information about this is the Job Accommodation Network, JAN. They have tons and tons of resources on their website about the costs of many very common easy to provide accommodations. The other thing is looking at the overall financial resources of the facilities and their effect on expenses. What is the business looking like? What is the impact of the accommodation on the facility? I want to share a story with you of a case and a situation that I had with a client about 2 years ago before I joined the commission. And here's what happened. I got a call from an HR manager, and she was quite frustrated because she said that this department head refused to provide a telephone amplifier device for his employee. She wanted an amplifier device for her phone. And she asked for him twice for this, and he declined it. And the third time, he said to her, I'm not going to do this for you, because if I have to do it for you, I have to do it for everybody else. So the HR manager had quite a long conversation with him about that, and he still refused to provide the accommodation. So as outside counsel, I had a phone call with him, and I'll share with you exactly how it went. This particular company is a Fortune 50 company. They are publicly held. So what I did is I went on the internet and I downloaded their 10K report. And when you went to like page 2 or 3 of it, it told you how much money this company made in this particular year in sales. So I had a conversation with the manager on the phone, and I said, look, I'd like to visit with you about this. I'm looking at your 10K report here, and it looks like to me you guys have had revenue in excess of $60 million. And he said, yeah, that sounds about right. And I said, this amplifier device that she's asked for is about $3 and some tax. He said, yeah, that's right. I said, this is what this could possibly happen to you at trial. It could be possible that if you took this case to trial, a plaintiff's lawyer would blow up the page on the left side of the screen at trial with the 60 million, and on the right side would be a receipt from Best Buy for $3.85. Actually, it probably would come from Amazon. What do you think a jury could conclude from that? And he was very quiet on the phone. And he said, well, I probably should provide the accommodation. I said, I think that would probably be a good idea. But these are some of the kinds of things that happen. And these are some of the kinds of stories and some of the cases that we see here at the EEOC, where employers are reluctant to provide some of the basic kinds of very inexpensive accommodations that an employee requests. So now let's talk about the interactive process. And there's a
Excuse me, Kat. This is wonderful. I just wanted to give a little, if we were in person, I'd be giving my 10-minute warning. We're at 2:48. We have wonderful questions. Some you've already addressed, but I just wanted to give you the heads up, and we'll get lots of positive feedback. Thank you.
Okay. No, I appreciate that. Thank you. Let's talk about the ADA interactive process for a moment. And the reason why I had the let's talk on the screen there is because that's what it is. It's a conversation. It's a conversation. So what we want to do is recognize the accommodation request, gather information about it, explore the options, choose the accommodation, implement it, and then turn around and monitor and evaluate that. When you look at this interactive process, you see that it is a process. It has a beginning and it has a fluidity to it. And it really doesn't end to the extent that the employer continues to monitor to make sure that the accommodation is working. So let's hit a couple of things. First of all, let's recognize that an accommodation request has been made. Again, the employee does not need to say, I need an ADA accommodation. Anytime that they are expressing that they're having difficulty performing a task of their job, or they need some kind of assistance, this should prompt, and it could be a proactive conversation that the employer could have with the employee. It could be things like, hey, I'm having trouble getting to work at my scheduled time. I'm undergoing medical treatments, or my wheelchair cannot fit under my desk. My back is really hurting and this chair is very uncomfortable. So sometimes what's necessary is for managers to be trained to recognize an accommodation request and instead of ignoring it. Sometimes a request could come from somebody in an email. And again, managers need to be proactive and promptly respond to those kinds of requests. Gather information. So what is the nature of what you need? What is the job duty that you cannot perform or you need assistance performing? What information can we get from your physician or your healthcare provider that would give us information on how to evaluate how we can provide this accommodation for you? And that information gathering process is not a static thing. It is going to be a continual thing because the need for accommodation may change over time. The other thing that I want to mention to you as employers is this. Don't get into the box, if you will, of assuming that everyone needs the same kind of accommodation. That's not true. Someone with a visual impairment may need this kind of accommodation, and someone with a visual impairment may need something else. That's why when we talk about the interactive process, it is done on a case-by-case basis. So sometimes an employee may be having difficulty, but they don't know what kind of accommodation that they need. And so again, that's going to be a discussion of sitting down, examining that, looking at things like the job description and what that person is doing and what kinds of functions may need to be reassigned or modified or restructured. Going back to the job description, find out the functional limitation and the impairment. So here's the thing, and I think that employers need to be mindful of this, is that employees with disabilities are going to be the best people to know what their limitations are, rather than the employer making assumptions or maybe through their own biases of what they think someone who might have a visual impairment needs or what they think someone who has a hearing impairment might need. Ask the employee. They know what they need and they know it in the context of what their limitations are. So you want to make sure that the discussions are not overbroad, but do provide you with enough information to determine what the accommodation needs to be. Explore the options. Again, the best place to do this is the Job Accommodation Network. You can actually call them. They have a toll-free number, and they are phenomenal, a phenomenal organization that has just tons of resources. The other thing that is really cool when you go to their website, it's www.askjan.org. Click on there, and they have lists and lists of the different kinds of accommodations for all kinds of disabilities. And you can find a lot of information right there just on that. Let me end with this and remind everyone that the ADA and the FMLA and the PDA also have provisions that prohibit retaliation. So some of the kinds of retaliatory actions can be things like this: discouraging someone for applying for FMLA leave, or judging their performance negatively because they took FMLA leave during the year. Writing someone down or making disparaging remarks about someone because they made a request for accommodation, or treating someone differently because they made a request for accommodation, demoting them, or other kinds of unwanted is not the right word. I actually just lost my train of thought. But other kinds of actions that would chill their rights to come forward and request an accommodation. So what you have to have in order to have retaliation is you have a combination of two things, actually three things. You have someone who engages in protected activity, an employer who takes an adverse action. You combine those two things with a causal connection of time, and that's where you have retaliatory conduct. So for example, let's say you have someone that made a request for reasonable accommodation because they did not have enough time to qualify for FMLA leave. So they're a new employee. They didn't meet the 1,250 hour requirement, but they did make a request for leave. As a result of that request, they were terminated. That would be retaliatory conduct. So there's other things like that. I want to skip for a second because I want to show you something real quick. I want to show you some resources. Where can you find out information about the ADA? When you get the slide deck, I've hyperlinked these resources for you. There's the Employer Guidance on Employer Provided Leave and the Americans with Disabilities Act. That is the definitive read on what we were just talking about maximum leave periods and things like that. There is the Enforcement Guidance on Reasonable Accommodation, the guidance there on caregiver, disparate treatment with caregiver responsibilities. There's a whole bunch of stuff on the website about pregnancy discrimination. So for those of you that are small businesses, there's a fact sheet there for you. And then I've given you a whole bunch of links to where you can go and get all kinds of juicy little information from the Department of Labor about the FMLA. And then finally, you can actually go to our website to find other information. There's a tab for employees and job applicants. There's also a tab for employers and small businesses. There's a lot of really good information, very simple Q&As and fact sheets. And then you can also click on the link to find the nearest EEOC office where you live. There are 15 districts and there are area and local field offices around the country. And with that, we can take a few questions. Or two.
Sorry about that, Kat. I was going from screen to screen. This was wonderful. Thank you. And we're copying the questions down. So, we have a lot of very thoughtful questions that we may not have time for. And if we can, we'll see if we can send some information or links. Just picking which one to go on this one.
Okay.
In terms, if the ADA requires leave as a reasonable accommodation, is there an outer limit? How long must an employer permit an employee to miss work? Isn't this what the FMLA is for? And can undue hardship include the simple fact that the position is designed as a full-time position?
Okay, well, a couple of things. Let's answer the first question. One, the duty to provide leave does not mean that it is indefinite. Okay, so it's not indefinite leave. But understand there are two different purposes here. Okay, FMLA is job protection. The ADA is reasonable accommodation. They are two different purposes for two different reasons. So one of the things and what the courts have considered on this is what are the businesses need here? Let me give you an example. You may have a company that is a very large organization and they have enough people to cover someone who, can be off an extra 4 weeks, and that's not an undue burden. But what if you have another corporation or another company, maybe they're smaller, and they've already paid for a temp this entire time, and they've got 4 people trying to cover these different workloads. So for them to go much farther than 4 weeks would be an undue burden on them. I'm not going to give you a bright line answer because it's going to depend on the circumstances of the employer, and it's going to depend on the job. So the other thing you mentioned about whether a job is full-time or not, again, let's go back to the job description, because I've oftentimes seen situations where the way the job description is written, you really can't, I mean, it looks like it might be full-time, but it also looks like it could be part-time. So again, that's a case-by-case basis. Did it sound waffly? Wasn't trying to be.
I think that is the essence of the ADA. I think, can we take one more question, do you think, Kat?
Sure, absolutely.
Thank you. If an employee is not seeking accommodation before returning to work, but the employer has concerns about the employee's ability to fully do their job after taking an ADA-related leave of absence, what does EEOC say about an employer requiring the employee to give a return to work certification from their doctor before being permitted to return to work? Is there a risk of a claim of
Okay, there was a whole
disability
bunch of stuff in that
discrimination?
question. A whole bunch of stuff.
So I fibbed, it's
first
not just one question.
Yeah, there's a whole bunch of stuff in that. I think part of it is going to be a sit-down discussion with that employee about what's going on, okay? And the first part of your question didn't give me enough information to really work my way through that. So I would like to know some more information about what got him in the first place to accommodation and what got the employer to wanting a return to work. I'm missing some facts there.
And Kat, since we're at 3:00, how about we copy the questions, and if there are things that you can answer without legal advice, because we cannot do that, and with the understanding that this is just general because you're not getting the full picture, some of it might be, some of the questions might already have been answered or the areas covered in the very helpful links that you shared. But we've copied the questions and we'll share them with you. How is that?
Awesome. Thank you.
Right.
It's been fun. I'm so glad you were able to join us today for this presentation and this workshop.
Oh, thank you so much, Kat, for being our speaker. We got such wonderful feedback in the middle of the presentation. And Marcel, you can see why Marcel and I jumped at the chance to invite you
Thank
to
you.
be our presenter. Marcel, anything that you'd like to add?
Oh, no, I'm looking at some of the chats right now, and I'm getting fantastic, great presentation. And I echo that, especially because this is my first time seeing you, Kat. So excellent.
Thank you very much. I appreciate that very much. Jamie, do you have anything else that you'd like us to leave with?
I just want to say excellent presentation. Thank you so much. I hope you all learned as much as I did. Wonderful presentation, and we look forward to being able to serve you again sometime in the near future with some additional programming. Thank you.
And speaking of an additional programming, if I could give you a plug, on May 4th, we're partnering with the New York District Office and the Washington Field Office to give a workshop on mental health issues in the workplace. And who is one of our key speakers in that? Our very own Kat Grinder. So you can see that at eeotraining.eeoc.gov or email Marcel or me, and we can give you the link directly. But it's just going to be another fabulous day with Kat and other speakers on ADA, also issues of mental health and communities of color. So really a lot of novel things that we're really looking forward to. We hope you'll join us for that. And with that, I'd like to end the program and just thank you all. Thank my colleagues for helping us with the behind the scenes. Thank you, Jamie. Thank you, Kat. Thank you, everyone, for attending, and our wonderful interpreters and partner transcribers. Everyone have a wonderful day.
All righty.
Bye.